I'm going to go to my guest now, Idaho Attorney General Raul Labrador, who joins me. Case before the Supreme Court of the United States on trans athletes and on, well, the trans athlete issue as well as the trans athletes' manipulative attempt to kill the sports ban case. So, to AG Labrador, there's a lot to unpack here. Let's dive right in.
Good morning. Thanks for having me on your show.
So,
So in 2020, Idaho passed HB 500, which is the Fairness in Women's Sports Act, which was the first law in the nation protecting female athletes by ensuring that biological males cannot compete in women's sports. Immediately following the passage of that bill, Lindsay Hecox, a biological male, and the ACLU sued Idaho because they were being prohibited from competing on women's club soccer from Boise. At the time, we had a different AG, and the AG actually wrote an opinion for the legislature telling them not to pass this bill because it probably was unconstitutional. The federal district court and the Ninth Circuit ruled against Idaho and enjoined the state of Idaho from enforcing this law. And the Ninth Circuit even cited the prior AG's opinion in their decision in joining Idaho. So I became Attorney General. This was one of the reasons I ran against him for Attorney General. And I make this a priority in my administration to defend this statute. In fact, I had been in private practice before that, and I was representing some of the people who were joining the state of Idaho to defend this law.
so with the decision that this should go to the Supreme Court, what's the status there? The timeline,
Right.
the status.
Great question. So right now we're scheduled to be heard in January before the Supreme Court, but the ACLU pulled a trick. They decided a few weeks ago to file a motion before the district court here in Idaho and before the U.S. Supreme Court withdrawing their case, saying that Hecox no longer wanted to participate in women's sports, so their case was moot. And we strenuously objected to that. We said, look, we've been litigating this for 5 years. You have enjoined, the district court and the federal courts of appeal have enjoined Idaho from enforcing this law. And now on the eve of going to the Supreme Court, when we're pretty sure we should win a case like this, where we could win a case like this, you now want to withdraw this case. And that's fundamentally unfair to the people of Idaho, fundamentally unfair to justice. So we have been objecting to that. The federal district court agreed with us a couple of days ago and said that it was unfair to dismiss the case, and now we're waiting to hear from the U.S. Supreme Court to see if they're going to dismiss the case for mootness.
Apologies to everyone for the technical issues. With me still, the Idaho Attorney General, Raul Labrador, AG Labrador. I really appreciate your patience, sir. We don't always win the battle with technology, and I hope you can hear me okay.
I can hear you just fine. Live radio, it happens. No big deal.
It does. Now, you were making a great point about the actions taken by the ACLU when we lost connection. And, I think of a term that we hear often in law, which is jury nullification. Is this a similar principle of the ACLU trying to nullify this case because it's not likely to go their way?
That's what it looks like. In fact, the court said that the mootness argument was somewhat manipulative to avoid the Supreme Court review, and the court emphasized that after years of litigation, Idaho now has a fair right to have its arguments heard and adjudicated once and for all. So the district court kept our case active, and now we have to wait for the U.S. Supreme Court, because the U.S. Supreme Court also has to rule on this issue of mootness, and they're going to decide either tomorrow or Monday whether they're going to hear the case or not. Now, they could dismiss it based on mootness, or they could decide to hear all the arguments, or they could say, hey, why don't you wait till January to make these arguments about mootness? So it's interesting to see what they're doing. The ACLU is clearly trying to manipulate the court system. They've had 5 years of litigation where everything went their way, and now when things are starting to turn, all of a sudden they want to dismiss this case.
You know, you use the term moot court, and it's something that many law students will recognize. And, it's a difference between that and wandering to conjecture, as I see it. But if this case proceeds to the Supreme Court, what are the potential wider implications should the Supreme Court come down on your side of the argument, or in reality, the people's side of the argument?
Well, there's been a series of cases dealing with these issues. Just like this year, the court's Skermeti decision upheld Tennessee's child protection law, which provided some good precedent for us. They said that it was fine for Tennessee to protect children from gender-affirming care that cuts off their parts. We had a similar law in the state of Idaho that was in litigation, and right after the Skermeti decision, all the lawsuits against us were dismissed. So we're seeing a pattern now where the Supreme Court is actually following biological reality, really. I mean, it's inconceivable to me that we're talking about these issues in the court and that we've had litigation for 5 years on issues like this. I think 80% of Americans understand that boys should not be participating in girls' sports, that it's fundamentally unfair to the girls who are competing, who are training, who are trying to do the things that they need to do. President Trump has been a champion, and my goal is to make it safe for women and girls to compete and to excel in competitive sports. That's what Title IX was about many years ago. There's a different case from West Virginia where they're debating that argument. It's going to be heard on the same day, dealing with the Title IX issues. So I think this is a good precedent for that. We're seeing some things, but you never know what the U.S. Supreme Court is going to do, and we're praying for the best.
You've had a significant amount of support for this case. Amicus briefs have been filed from multiple states. Are there others supporting the case outside of the various states' attorney generals, other organizations, and the like?
Yes, there's been over 45, I think is the number of amicus briefs that have been filed before the court from churches, from religious institutions, from university faculty, from people who have competed in sports, former female athletes. I mean, from a bunch of different people saying that this shouldn't be happening in the United States. So I think we have a lot of support. For the last 5 years, people were scared to say publicly that this was unfair because I think they were shadow banned on the internet. X was going after people at previously Twitter. You would get canceled if you said that this was unfair. People would try to shame you publicly if you said this was unfair. And I think finally America's had enough. I think the public has decided, the silent majority finally decided to be heard, and I think things are going in the right direction.